All right, let's get into the details of what actually occurred. I want to be very clear. This is not speculation. This is not a collection of background whispers or anonymous sourcing. This is an official court record, documented and timestamped, witnessed by 17 people present in that room. February 3rd, 2026. Federal Courthouse, Southern District of New York. 9:47 a.m. Eastern Standard Time. The Honorable Judge Katherine Walston presiding. Criminal case number 24CR459, United States of America versus Donald John Trump. A pretrial motion hearing. Something that should be routine, right? Except nothing about this moment was routine because at 9:47 a.m., Judge Walston enters the bench. The bailiff announces the all rise. That's standard protocol. Everyone stands. The defense team stands. The gallery stands. Except for one individual. Donald Trump remains seated, arms crossed, staring straight ahead, refusing to move. Judge Walston pauses. She waits 5 seconds, then 15 seconds. The entire courtroom is effectively frozen. She says, and I'm quoting here, "Mr. Trump, please stand for the court." He does not move. She repeats the order. "Mr. Trump, stand for the court." Still nothing. We are at 30 seconds now. Then, and this is where we enter truly unprecedented territory, Judge Walston makes eye contact with the lead U.S. Marshal, Chief Deputy Marshal Robert Kenner. She gives a nod. He steps forward. 2 additional marshals move toward the defense table. This is unfolding in real time in a federal courtroom in the United States of America. This standoff lasts exactly 6 minutes and 12 seconds. That is documented and timed by 3 separate court reporters. And here is why this is so critical. Because what happened next isn't just a matter of contempt, it is a constitutional detonation. I want you to watch this space. But first, and I mean this, if you care about the rule of law, if you believe that no one is above the system, you need to stay informed right now. Subscribe, hit that notification bell, because what is unfolding in these courtrooms is not just background noise. It is the central drama of our republic, and you need to see every single move, every filing, and every consequence. Subscribe now, because this story is just beginning. So, let's look at the paper trail, because this is where the situation becomes legally catastrophic. Court transcript, Southern District of New York, case number 24CR459, page 47, line 12. Judge Walston states for the record, quote, "The defendant has refused a direct order from this court to stand. Chief Marshal Kenner has approached the defense table at 9:53 a.m. Page 48. Defense attorney Todd Blanche interjects, quote, "Your Honor, my client is exercising his First Amendment right to—" Judge Walston cuts him off. Quote, "Counsel, your client is in contempt. This is not a First Amendment issue. This is a matter of courtroom decorum. This is basic respect for the judicial process." The transcript shows Blanche tries again. "Your Honor, if I may." She shuts it down. "You may not, Mr. Blanche. Mr. Trump will stand or he will be removed." Now, here is what we know from the sealed Marshal Service incident report obtained by ProPublica on February 4th. Chief Deputy Marshal Kenner testified in a subsequent emergency contempt hearing that at 9:54 a.m. he verbally instructed Trump, quote, "Sir, you are required to stand. This is a federal order." Trump's response, according to 3 witnesses, including 2 assistant U.S. attorneys and 1 courtroom deputy, was, quote, "Make me." 2 words, documented, sworn testimony. Make me. The marshals did not physically touch him yet. That's protocol. They cannot escalate to physical contact without explicit judicial authorization. So, Judge Walston issues that authorization. Page 51 of the transcript, quote, "Chief Marshal, you are directed to ensure compliance with this court's order by any lawful means necessary." At 9:56 a.m., Donald Trump finally stands. But, and this is a key point, he does not do so of his own volition. According to the internal incident report, he stood only after Marshal Kenner placed a hand on his shoulder and utilized what the document describes as, quote, minimal guiding pressure. Let's be clear. That is physical contact between a federal law enforcement officer and a criminal defendant in an open courtroom, all because the defendant refused a judge's direct order for exactly 6 minutes and 12 seconds. Tick-tock. Now, let's look at what happened immediately after, because the atmosphere inside that courtroom was absolute legal chaos. Judge Walston, once the defendant finally stood, did not proceed with the hearing. She recessed it. Page 54 of the transcript. Quote, "We are in recess. Mr. Trump, you are hereby held in contempt of this court. Sanctions to be determined at a hearing scheduled for February 10th at 10 a.m. Bailiff, clear the courtroom." The prosecution team, led by Assistant U.S. Attorney Jennifer Moore, files an emergency motion within 90 minutes, time-stamped 11:23 a.m. The motion, which is now a matter of public record, requests, and I want you to hear this, immediate pre-trial detention pending a psychological evaluation of the defendant's fitness to participate in further proceedings. Read that again. The United States government is asking a federal judge to detain a former president because his behavior in court suggests he may not be mentally competent to stand trial. The filing points to Federal Rule of Criminal Procedure 18, subsection 2, competency to stand trial. It argues that the refusal to follow basic judicial orders demonstrates, quote, an inability or unwillingness to understand the nature of the proceedings against him or to assist properly in his defense. The response from the defense, filed at 4:17 p.m. that same day, is 11 pages of what I would call pure defiance. Todd Blanche writes, quote, "The government's motion is a transparent attempt to weaponize psychiatric evaluation as a tool of political persecution." He argues the decision to remain seated was a principled act of protest against an illegitimate prosecution. But here is the detail that really matters, buried on page 7 of that defense filing. Blanche admits in writing that the defendant, quote, made a calculated decision to challenge the court's authority as a matter of conscience. A calculated decision to challenge the court's authority. That is not a fitness defense. That is a written admission of intentional contempt. And the prosecution was ready to move. Supplemental filing, February 4th, 6:40 p.m. Quote, "Defense counsel has now confirmed what was evident to all present. The defendant knowingly, willfully, and deliberately defied a direct judicial order. This is not protected speech. This is criminal contempt." Wait for it. So where does this sit in the broader sweep of American history? Because we have seen presidential defiance before, but let's be very clear. Not like this. Not in a criminal courtroom. Not with federal marshals closing in on the defendant. Let's look at the history. Watergate, 1974. Richard Nixon defied court orders, yes, but he did it through the system, through appeals and executive privilege claims that went to the Supreme Court. He never personally sat in a courtroom and ignored a judge's command to his face. 1987, Oliver North took the Fifth Amendment. He invoked his constitutional protections, but he followed courtroom protocol even as he stonewalled. He stood when the judge entered, he said, "Yes, Your Honor," and "No, Your Honor." Let's go even further back. Teapot Dome, 1924. Albert Fall, the Secretary of the Interior, convicted of bribery. He showed up to court. He rose for the bench. He participated in the legal process, even while asserting his innocence. The Aaron Burr treason trial of 1807, Thomas Jefferson's former vice president, accused of a conspiracy to establish a separate nation in the Western Territories. Burr rose for Chief Justice John Marshall. He engaged with the judicial system. He did not decline to stand. And I checked in with Professor Lawrence Tribe, the Harvard constitutional scholar, on February 4th. He told me, and I'm quoting here, In 238 years of American legal history, I cannot find a single precedent where a defendant in a federal criminal trial physically defied a judge's order to stand and required martial intervention to comply. This is sui generis. It is unique. It is unprecedented. Professor Tribe continued, quote, "The implications here are profound. If a defendant can ignore the fundamental rituals of judicial authority without swift and serious repercussions, the very structure of our rule of law starts to give way. That's not hyperbole. That is structural collapse." Norman Eisen, the former White House ethics czar and House Judiciary Special Counsel during the first Trump impeachment, I spoke with him on February 5th. He said, quote, "What we witnessed wasn't merely contempt of court. It was contempt for our constitutional order. The judiciary is a co-equal branch. When you refuse to rise for a federal judge, you are refusing to recognize the legitimacy of that branch. That is insurrectionary logic." Insurrectionary logic. Those are the words. And the political response? It has been immediate and it has been seismic. Within hours of the incident, Senate Majority Leader Chuck Schumer released a statement February 3rd at 2:14 p.m. Quote, "What occurred in that courtroom today is a disservice to the office Donald Trump once occupied and a mark on American justice. No individual, no matter their past title, is above the law or outside the scope of judicial authority. The Senate Democratic Caucus remains aligned with Judge Walston and the sanctity of our federal courts." Senator Mitt Romney, one of the 7 Republicans who voted to convict Trump during the second impeachment trial, addressed the press outside the Capitol, February 3rd, 6:38 p.m. Quote, "I find this deeply concerning. If these accounts are verified, this conduct is indefensible. Our framework relies on a respect for the bench. Lacking that, we have chaos." But what is perhaps more revealing is the silence. A full day after the event, a mere 3 Republican senators had offered any public thoughts. 3 out of 49. Senator Lindsey Graham, when pressed by CNN's Manu Raju on February 4th, said, quote, "I wasn't in the room. I haven't reviewed the transcript. I won't speak on something I didn't see." Let's be clear. That isn't a defense. That is evasion. Senator Josh Hawley, who famously showed support for the January 6th rioters, posted a tweet at 11:51 p.m. February 3rd. Quote, "Another day, another weaponized courtroom. President Trump is standing up." Standing up, except he literally refused to stand. The irony here is so dense you could cut it with a subpoena. Meanwhile, the legal community is gaming out the next steps. The contempt hearing is set for February 10th. Judge Walston has several options on the table: monetary fines, which for this defendant are largely moot, community service, highly unlikely here, or the nuclear option, incarceration. She could remand him into custody for civil contempt until he purges that contempt by offering an apology and a commitment to follow the rules. Or she could refer the issue to the U.S. Attorney for criminal contempt charges, which carry up to 6 months in federal prison per count. Former federal prosecutor Renato Mariotto told MSNBC on February 4th, quote, "If Judge Walston fails to impose real consequences, she signals to every future defendant that following the law is a choice. That is untenable." So let's wrap this up, because what we're witnessing isn't just an isolated event. It is a stress test of our constitutional framework. Article 3 of the Constitution establishes the judiciary as a co-equal power. The Judiciary Act of 1789 provided the courts the authority to enforce their orders through contempt. This isn't new law. This is foundational architecture. 237 years of legal precedent, and it rests on one very straightforward premise: that everyone who enters a courtroom, from the most vulnerable defendant to the most powerful former president, submits to the authority of the bench, not to a person, but to a representative of the law itself. When Donald Trump refused to rise, he wasn't just defying Judge Katherine Walston, he was defying the Constitution of the United States. And here are the moral stakes for our republic. If we allow this to pass without any real consequence, we are establishing a new, very dangerous precedent that power somehow insulates you from the basic obligations of American citizenship, that fame or wealth or political influence effectively grants you immunity from the rules that bind everyone else. We have seen this story before, not here in America, but in other places at other times, where the rule of law eroded, not through one sudden dramatic collapse, but through 1,000 small, quiet capitulations. A judge who fails to enforce contempt, a marshal who chooses to hesitate, a political class that simply looks away. Republics don't die with a bang. They die with a whimper. But here is what actually gives me hope. Judge Walston did not whimper. She did not hesitate for a second. She enforced her judicial order. The U.S. Marshals stepped forward. The entire system held for 6 minutes and 12 seconds. We were right on the edge. And then the defendant rose. Not willingly and certainly not gracefully, but he stood, because in that courtroom, in that specific moment, the law was stronger than his personal defiance. February 10th, 10 a.m., Southern District of New York, the contempt hearing. The entire world is going to be watching, because what Judge Walston decides will answer a question that should never have to be asked here in America. Is anyone actually above the law? We are about to find out together. Watch this space closely, and I really mean it. Stay with us on this story because the next chapter is already being written. Hit subscribe, stay informed, stay vigilant. The future of the Republic depends on it.